You don't look real sure of that, Jeff.
I had to double check. Well, for some reason, Dennis decided today that I was going to send out the link and do all of this, and I'm not the tech guy when it comes to Zoom. I'm pretty good at some of the other stuff.
I'm trying to teach him to fly, you know? You got to push him out of the nest, maybe.
Exactly.
But I said I'd be here in case you got in trouble.
Yeah, Dennis never started off with swim lessons in the shallow end. He pushes you right off the pier. Okay, so we've got,
right?
oh, look at this. Yeah, I apologize that I have to admit you guys. I'll fix that for next time so I don't have to do that. Now, how do I, Dennis, with the tech guy, how do I put my computer on Do Not Disturb?
Yeah, I just.
Do you mean your screen, or do you mean what?
No, so all my, so the dinging you guys hear doesn't continue to go on.
Filed it today. Ooh. I mean, that makes me, I guess, slightly nervous that they picked the day before, but there's just no way they're going to process that.
So you would have to go into your audio setups and click the tab and tell them not to ding.
Like I said, I'm going to walk you.
If it's not that bad, just let it go. It comes through very lightly.
Okay.
Well, I guess she wasn't, you know, she's going to do the.
We're good. We're up to 42 participants, guys.
A record.
No, the thing that Aronson did to Chris. Well, I guess you just really weren't interested. I had 900 questions for you, but you estimated 5 minutes.
Where's Mark at? Let's see if I can mute you, Mark. Mark, we're glad to have you with us, but we can hear everything you're saying. There we go. You're muted now. Okay, well, it's about, what is it, 6:05? Is that what you guys have? 6:03. I'll wait a couple minutes and we'll get started. Mr. Denari, there's no working out during the video, no distractions.
Jeff, it's Kate Corrigan. You look way too man cave-ish here.
Oh, really? I'm in the dining room.
No, I like the beard here.
Oh, yes. This is
Todd.
definitely the COVID beard.
Okay.
Well, thanks for joining us, Kate. We've got a great turnout so far.
Yeah, I just
Mark Brown is here in the house. Thanks for being here, Mark. See lots of, we got some new faces in here too. The vice president's in the house, Fernando.
Steven is anonymous.
Yeah, Fernando's trying to be low key, but I think Fernando's iPad gives him away.
I'm in, guys.
Hey, Fernando.
What's up? Hey, Judge Mahler, what's going on? We need you at West Court. North Court's over there now.
I know everybody's over it. West Court's got a few judges, and everybody's got a few North Court judges. I saw Easterson. How's Easterson doing?
He's doing great.
Hey, Your Honor. How are you doing? Good to see you.
Good to see you, Mike. It's nice to see you.
He's in W4.
Hanging in there.
Well, you got your office has got to be scattered all over the county now, Mike.
We are actually. We are scattered around. It's a little hectic, but we're getting through it.
I get to see you 2 days in a row, Your Honor.
Dr. Harry, nice to see you.
Good to see you as well.
How are you doing?
Not bad. I've been out in Riverside a little bit. I was telling Rudy Lowenstein that I was out there. I'm back out there in November, but not much in between. I'm actually going to be out in Banning. That's the sad part.
I have not had that experience
Hey,
yet.
Kim.
Okay, guys, it's about 6:05, so let's go ahead and get started. if I can, I'm going to ask everybody that hasn't to please mute themselves so that we're not hearing all the excitement in the households. But I just want to say thanks for everybody for joining us. Looks like it's going to be a really successful meeting. We're up to about 53 participants. That's great. Jess, I think you have a record, so you can put that on your mantle, and we'll make sure that Mr. Spitzer knows about you being the #1 Zoom cast, because I'm sure him being here only cost you probably 10 or 15 viewers. So, that's so don't worry so much about that. But thanks, Judge Mahler, for being here. Thank you, everybody. Kate Corrigan's here. I saw Mark Brown was here. So it's great to have a lot of new people here. If you see me getting distracted, for some reason, I've set it up to where I have to admit each one of you as you come in. So if you didn't hear me already, please put everything on mute if you haven't already. You can choose to be your video or not video, but please mute your audio. And we're going to get started here in a minute. But the first thing I want to do is, again, thank everybody for being here. One of the reasons that North Orange County Bar Association is the best bar association in Orange County is because we put on great events. We do great things for the public and for the county. We want to be able to continue to do so. And to that end, we just had our elections for the 2 open seats on the board. As you know, Rick Kern had termed out. And then as I became president, I resigned and actually termed out this January my board position. So we had 2 open seats. We were very lucky to have 2 great people that won the election. We have with us, we have Olga Giller. I'm not sure if she was able to make it tonight or not. And Lisa Leverson. So we have great new.
Hello, I'm here. Hi guys. Hi.
Oh,
everybody.
hey, there you are. Hi, Olga. How are you?
Just on parent duty, so I'm muting myself.
No worries at all. Thank you for joining us. And so, yeah, Olga, it was another deputy public defender we have on the board, which is great. We have a lot of diversity now. We've got DAs on our board with Kim Wah. We have city attorneys, Mike Easterson. We have 2 public defenders, Fernando, who we just can't get rid of for whatever reason, but at least we tried to balance that out by adding Olga. And then Lisa Leverson couldn't make it tonight because it's her birthday, so we gave her the night off. I thought that was a decent excuse. So the family's taking her out to dinner. But it's that new blood and having people with diverse backgrounds that really helps us to be able to do new and different things with the organization. It gives us a breath of new life and helps us to be able to move forward. So I'm really excited about that. It's going to be great. As you know, tonight we've got Jess Rodriguez is going to talk about mental health diversion, nuts and bolts in just a few minutes. But I also wanted to let you know that we're not sure what's going to be October and November yet. Things are in the works. We've got some great ideas out there. Kim was trying to see what she can do, and maybe Mr. Spitzer can help pull some strings. We're trying to maybe get some of the prosecutors from the Golden State Killer case to maybe do a seminar. So
that'd be great.
We're going to reach out to.
That'd be
Yeah,
great.
we're going to maybe reach out to Sacramento and see if we can get. I know we had some of our DAs on it, but I was hoping, and Kim had some contacts, and with you, Todd, maybe we can get some of the lead counsel from the Golden State Killer, because I think sentencing and everything's been taken care of, right? So we're past all the victim
impact
statements.
Yeah, it's all done. I mean, Debbie Lloyd was working on the case for 10 years. I mean, she's an expert from her office.
Great.
We could provide that. That'd be great.
Awesome. Yeah. So yeah, maybe we can get Debbie and we can get somebody from Sacramento area. So that's one of the things we're looking at doing. Another one we want to do is a court update. We thought that for a few minutes, we thought we were maybe late on that because we're going to have Judge Pham and then Judge Slaughter from North talk about what's going on with COVID and everything, but it looks like COVID's here to stay for a while. So maybe it's not too late to have that meeting still. And as most of you know, and if you don't know already, North Court has been closed effective midday Friday of last week. And I think it's closed through October 2nd right now. And I'm hearing rumblings that that may be wishful thinking and that it may be longer than that. So for right now, North Court is closed through October 2nd. I do understand, and Kate sent out an email, and maybe I should give you a minute to talk about that, Kate, that they assigned things to West Court and some other courthouses, and now I think they're reassigning things because it's lasting a little longer than they thought. Kate, did you want to add anything to that? she may not be there. But at any rate, North Court's got some changes. So I understand that the assignments that we had last through.
Hey, Jeff, actually, I can add. Sorry, I was driving, so I had to wait till I got to a stop sign. I don't want, any of Newport's finest pulling me over. Yeah, so I'm going to keep all of you updated. The court is Todd's one of the judge's partners along with me. So I'll keep everybody updated through Facebook and through my email distribution. If anybody's not getting my notices, just shoot me an email and I'll add you. So, because obviously I've got the updates on Harbor also, because there's some stuff that's going on a little bit on Harbor that's different. October 2nd right now is the date, but I agree with you, Jeff. I think this is just, it's just a start.
Yes, 2020 is here to stay, isn't it?
Yeah.
Unfortunately. Yeah, so I understand, Kate, we have some new assignments for judges that are going to come out. I think I received an email from you today.
Yeah, I sent that out a couple hours ago, and then I anticipate we're going to see more of that coming out. So I will, as I get it, I literally turn around within moments of getting the updates. So you guys will get them as quickly as I get them.
Great. And if you're not on the email list server, let Kate know, let me know, and I'll make sure you get on it. We're also trying to duplicate things on the NOCBA Facebook page, as well as the Orange County Criminal Lawyers Facebook page, to try to make sure everybody's got access to that, and putting the PDFs with the assignments up. So we'll continue to do that to try to keep everybody notified.
Yeah, and I am also posting on the Criminal Defense Facebook. But I would, just to reiterate, if anybody wants to be added to my distribution list, please just shoot me a quick email. And it takes me about 2 seconds to add you, and then you'll be getting emails from me, till I croak.
Well, hey, Kate, really, we do appreciate it. I know that I talk to lots of people, and they very much rely on your emails and updates throughout COVID and now with the court closure. So thank you very much for that. The other thing I wanted to do is just tell you guys that if you haven't heard already, the holiday party has been canceled. That was, unfortunately, we'd been putting off that decision, and then the hotel made the decision for us by just basically saying that they can't host that many people, and they have no reason to think they'll be able to do differently. So the holiday party is canceled. So the next big event we will have will be the July soiree. We're going to hopefully make that a little bigger than normally. And then as far as, face-to-face meetings, we can't really do that until I can get at least 50 people in a room. And right now we can't do that. And today we're at 59 people. So, tonight even if it was at 50, we would have had to close the doors on some people, and I don't want to do that. So for the foreseeable future, things will be by Zoom, and hopefully everybody's getting accustomed to that and enjoys that. We're also making these available on the NOCBA website, so that if you did miss the meeting, you can go log into go to the NOCBA website, and you can actually watch these later. So that's great. And the holiday party, like I said, is canceled. We've got 2 new board members. I do want to give 2 minutes to Steve Goodman from Steve Goodman Bail Bonds. He's going to lead us into me thanking our sponsors by talking to us a little bit about Prop 25. If you guys don't know what Proposition 25 is, Steve Goodman, are you there and are you ready?
I am. You can hear me? Yes?
Yes.
Okay, so Prop 25 is the referendum now for the public to vote on what happened with SB 10. SB 10 was to get rid of cash bail. So the challenge is, does bail need to be reformed? Sure, the system of it, the way that it's set up at the present time, with each county deciding what their bail schedule is, which makes it confusing if you're going to LA County, Riverside County, so forth. But Prop 25 actually eliminates cash bail. So it's not really a reform. It's eliminating the option for anybody who gets arrested to have the ability to bail out their child, loved one, or like as we see with domestic violence, sometimes it was an argument and they want to get out their spouse or significant other, and they would at that point in time have to wait. SB 10 also releases everybody with misdemeanors, which is almost as what we are at the present time.
That's what she's talking.
And yes, Prop 25 is going to be on the ballot on our election in November. We would like, of course, everybody to be able to vote no on it. It also, there's a challenge of it in the sense that the ACLU also supported SB 10, and when
the way it was is that they won.
they changed their form, they changed their opinions. They think it's actually fair because then it actually, there's no option for judges at that point in time. It's either keep the person in custody or let them go. There's not an option of following a bail schedule that gives them, hey, this is what the bail schedule is. This is what you need to do to post to get out. You are a danger to society, or you might be a flight risk. If they deem that that person is a danger to society or a flight risk, then they have the prerogative to just keep them in custody the entire time, which will affect your clients at that point in time. It sounds good. Fluff-wise, it sounds excellent from a perspective of poor people can't get out of custody because of the extreme bail schedule, but it's in each county. The way to solve that is actually probably to create a statewide bail schedule instead of each county. But they didn't put that on the proposition. It's either to eliminate cash bail and then have pretrial release determine if that person is a flight risk or a danger to society, and then be seen by a judge to determine that as well at that point in time. So it kind of, we're not ready for it at this point in time. There's not a better alternative other than cash bail as of now. There's not enough options out there. And plus the states that have gone in that direction, they find that nobody's showing up to court, and it's becoming a problem. Does anybody have any questions?
Well, thank you very much, Steve. And you guys know that we've got some great sponsors here. Steve Goodman's one of them with Steve Goodman Bail Bonds. We've got lots of other great sponsors I want to thank, and I see lots of them are here with us tonight. We've got Options Diversified Monitoring. That's Al Martinez and Jason Guevara. We've got the MOST program with Dean Stepper and Suzette Casillas. We've got Premier Bail Bonds with Sean Cook. We have Hotel California by the Sea with Janny Nelson and Lindsay Gasser. We've got True Recovery with William Walker. We've got Breathe Easy Insurance with Chris
I'm
Ballou,
gonna take a pain med.
Trey Roberts, and Jared Mahoney. We've got Cornerstone of Southern California with Simon Stone and Leslie Nolan.
Do I need to
We
take
have
food with that?
Insight Psychology and Addiction with Dr. Stephanie Herring. We have Nancy Clark Alternative Sentencing Programs with Nancy Clark and Winter McDaniel. I see Winter's joined us tonight. Thanks, Winter. We have Imminent Appearance Attorneys with Mike Moore. And last but not least, we have Bad Boys Bail Bonds with Joe Blunt. And I didn't see whether Joe was here or not, but we're very fortunate to have all these great sponsors, and that's what keeps us up and running. I mean, obviously, things have been a little more cost effective with webinars, but as you guys all know too, that we run the holiday party at a big loss every year. So to help us maybe do something a little extra special. With that, I wanted to go ahead and introduce a really good friend of mine. You guys probably know him as our Deputy District Attorney, Todd Spitzer. He's going to talk just a little bit about.
You still demoted me, Jeff.
I know. I'm sorry.
You just demoted me.
Or District
That's okay.
Attorney, Deputy District Attorney, Senior District Attorney, Chief District Attorney, whatever. Sometimes you got to work your way up again, Todd. But one of the reasons that, I mean, amongst us being friends for other reasons and stuff, one of the reasons I think Todd was a great selection for DA is because he is open to lots of different alternative sentences. He's not just here in the county, I think, to lock people up no matter what. He's here to reduce recidivism and try to keep the county crime free. And locking up certain types of individuals doesn't fix the problem. Some of those individuals have mental health issues. Some of those individuals are military and veterans that have conditions that they've got as part of their service for our country. And Todd's been a big proponent in both of those. And to that end, he created, as one of the new units in the office, a unit called RU, or better known as the Recidivism Reduction Unit. And Todd, you have the floor.
Well, thank you so much, Jeff, and thanks for having me. Let me just start with kind of a little background. So my cousin Patsy is a paranoid schizophrenic. And I lived with her dad when I was going to law school. I was doing my master's at Berkeley and my law degree at Hastings. And my cousin Patsy was always in trouble with the law. She wouldn't take her medication, and she didn't do anything extremely serious, but you know, she'd throw hot coffee on, you know, innocent people who she was paranoid, and she was always in trouble. And I could just, my 80-year-old, my great uncle I lived with, 80 years old, it just tore him apart. I mean, he literally didn't have the ability to deal with Patsy. And so I think everybody on this call tonight has either personal experience with mental illness or somebody close to them with mental illness. The only thing I ask tonight, Jeff, is that Ray Denari is not allowed to wear a tank top on these calls, okay? Ray, just make sure you like cover yourself up, okay? I can see you in that tank top. That's the only thing that's distracting me right now. But
just for you, we're going to impose a dress code, but it's only going to apply to Ray. So the rest of you are okay.
I appreciate that. But in all seriousness, the legislature created AB 1810 in 2018. That became the law in January 1st of 2019. And so it allows for basically pretrial diversion. And irrespective of the fact that the law allows that, I decided in March of 2019, so right after I got sworn in, to create this new unit that you described. And I'm just so thankful that Jess Rodriguez is presenting tonight. And he took the leadership in the office with Scott Zidbeck to create this unit and kind of evolve this unit. And it's evolving as we speak. The law is changing. We're taking on cases. We're learning. We have prosecutors in our branch courts. We have experts we're trying to develop in our office, and we're real serious about getting people help who need help. And you know your clients best, and they trust you. And so if there's a program or a way we can work this out, then I want them to listen to you, and we want to cooperate in working with the court to figure a disposition that is in their best interest, at the same time allowing us to protect society. So with that, Jeff, I'd introduce Jess Rodriguez, Assistant District Attorney. I didn't know if you wanted to do that, but I'm so thankful he's here tonight, and I'm so thankful for the opportunity to address everybody. Thank you.
Thanks again, Todd. We really do appreciate you being here. And thank you for those for kind words to the organization and to Jess. And Jess, I want to say thank you to you for being here. And I think I have set things up to where you have control. So so hopefully you'll be able to share your screen and stuff. If not, then they're gonna have to bear with us while we figure that out. But the floor is yours, Jess. Thank you very much.
Hey, thank you very much. And thank you to DA Spitzer for the introduction, and to NOCBA for inviting me to this. I think when Kim Wah first approached me about doing this presentation, it was back in April or so. And I said I was absolutely interested and I wanted to talk about mental health diversion. But I told her I really wanted to get the true NOCBA experience. And so I asked if we could put it over until we could get back to the Matador and I could, take in the true experience. So we put it over till June. Because obviously we assumed that in June everything would be good and fine and we'd all be back in person. And now we are almost in October, and instead of taking in the aroma of the Matador and mingling with all of you in person, I'm taking in my office and the aroma of Civic Center Drive instead. But I guess the one common thread is either way we were getting Ray Denari in a tank top. So I have that connection. So yeah, I'm going to share my screen here and hopefully that does work, because if it doesn't, this is going to be a really awkward presentation. All right, I'm getting a thumbs up. So I'm going to go ahead and get going. The plan here is to kind of walk through mental health diversion from the beginning to the end, how we got here, and where things are kind of going. It's going to be kind of a nuts and bolts presentation, but there are other things I want to talk about along the way. Mental health diversion is kind of weird in that in some ways it seems very strict and rigid and there's very specific requirements. And in other ways it's completely chaotic and there aren't any real standards or protocols for lots of other things. So this is where we're going. I kind of divided it up into two parts. Part one, everything that kind of takes place before the actual hearing, as far as preparing for it. How do we get here? Who's eligible? And when we say who's eligible, really we're talking about like what charges are eligible. What are the requirements? What are those criteria for getting someone approved for diversion? And then of course, how to file it. That'll be kind of the nuts and bolts section and the procedural part of mental health diversion. Then in part two, I'm going to talk about what goes on at the hearing, and it's more, rather than talking about requirements, just talking out maybe some suggestions or different ideas for how these hearings could go, should go. But as you'll see, a lot of it is really going to be controlled by the defense. So all I can do is kind of give, based on my experience and what I've seen, some things that I think help the process versus drag it out a little bit. How do hearings work? What happens if your hearing's denied? What happens if it's granted? And of course, how does it all come to an end? I'm going to do something that is really bad advice for anyone giving a presentation, something that you would probably never get recommended to do. And that is I'm going to take what I think is my favorite part of this presentation and one of the biggest takeaways that I hope you all get from it. And I'm sticking it kind of in the smack dab middle of the presentation. That is terrible practice. No one would ever tell you to put your best arguments in the middle of your closing. But I'm going to do it for a couple of reasons. Number one, I know this is a higher educated, highly sophisticated group that can bear with me and understand context and remember to tune in at the part that I think is really key. And number two, just makes sense with the flow of this presentation, kind of going from start to finish. I didn't want it to be choppy. So just know that when we get to the middle, there's going to be a section there that I hope is kind of the big takeaway and fits in with what DA Spitzer was talking about as far as why we have this unit, the RU, what we're trying to accomplish, and how it ties into mental health diversion. All right, so first step, how do we get here? Pretty straightforward. Back in 2018, when we all had no idea what our lives would be like 2 years later, Assembly Bill 1810 got passed through with the stated goal of creating an option of pretrial mental health diversion for defendants who met certain criteria. And the legislature was good about telling us what those criteria were and being very specific. And then everything else, they said, all right, now you guys figure it out. And so the counties and the departments were really kind of left to themselves to figure out, all right, well, we have this option now, but how do we enact it? How do we actually give someone diversion, and what does that look like? So this got signed by the governor in June of 2018 and codified as Penal Code 1001.36. As the district attorney was talking about, one of the things our office did to take on issues dealing with mental health is create the recidivism reduction unit. So in March of 2019, District Attorney Spitzer created the RU. I was asked to take the lead on figuring out what exactly that would look like. You know, that every prosecutor wants to reduce recidivism, but when we talk about it in this context, what exactly does that mean? And so the first step was to kind of get a sense of what was going on in Orange County, figure out all these different groups that were trying to do different things, suggest different programs. And one of the first things that I saw that with all the new laws and all the new issues popping up, whether it's PTSD, diversion programs, mental health diversion, there are all sorts of different groups and people starting to get specialties, but at least in our office, they weren't all under one roof. So what we wanted to do was establish a unit that could kind of be the nexus or the brain of all these issues, so that if there, wherever a case was in our criminal justice system, we would have someone that would have some expertise in that particular issue, whether it was mental health, whether it was the collaborative courts, AB 109, restitution, things of that nature. So after kind of exploring the scene for a few months, we started up a mental health division within RU. We were lucky to get a couple of experienced prosecutors who could be given the assignment of focusing on mental health issues that pop up within kind of the traditional criminal justice system. So that would be stuff happening outside of the collaborative courts, 1368, competency to stand trial, 5150 issues, conservatorship issues, and then a big chunk of their assignment became taking on these mental health diversion motions as they were starting to become more and more commonly filed in our court system. And one of the, I think, great benefits to having them under RU as well as the collaborative court DAs is it let them cross-train, kind of learn what each other was doing and communicate with each other. And I think when we get a little further along, you'll see how that is already paying off. So who's eligible? Who's eligible for mental health diversion? Well, it's probably easier for me to list who is not eligible. If you're just talking about what charges are eligible, the only ones that are ineligible: murder, sorry, your murderers will have to find alternate options. Voluntary manslaughter, all 290 charges except for 314, and weapons of mass destruction. So if you got a client who's walking around with some WMDs, diversion is not an option for him, at least not yet. And eligible is everything else. So that's the easy part. As long as you don't have one of those charges in your current case, you are eligible to file a mental health diversion motion. Of course, that doesn't mean that you are going to receive diversion. That takes us to the next step, which is what are those requirements? So when you're filing a diversion motion, what are those things you're going to list and make your pitch for? Those are the criteria that the legislature actually gave us some specifics on, but as you'll see, they are specifics that as soon as you start to poke and prod as to what some of these terms actually mean, the answer is kind of figure it out. What are those things? There are six. There are 6 requirements, and neither is any greater than the other in that you're going to have to meet all 6 of them. I'm going to show all 6 of them right here, and then I'll talk about them individually. So if it flies by a little fast, don't worry about it. We'll come back to each of them. Number 1, you're going to need a qualifying disorder. Next, you're going to need a nexus between that mental disorder and the charged crimes. Third, you're going to need an expert opinion that your defendants, the symptoms of your defendant's disorder will respond to treatment. You're going to need your client to actually consent to diversion and consent to treatment. And those are 2 similar but slightly different things. And then one of the big ones, obviously, from the DA side, is there needs to be a finding that the defendant is not is that a double negative, not an unreasonable risk. And we'll talk about what that means. But before we get to that, about those requirements, like I said, all 6 must be met for the defendant to be eligible. And my favorite part, it is the defense burden. Finally, it is the defense burden, not the prosecution. So after years and years of voir dire, listening to a defense attorney tell the jury how they don't have to prove anything and they can sit and play cards with their client. Yeah, I see people shaking their heads. You should feel seen right now. It finally gets to be me. I get to sit there and tell the judge that I don't have to prove anything, and I can sit and, I guess, play solitaire since no one's up there with me. But it's the defense burden, which changes a lot of things as far as the perspective of how the hearing goes and how the court's going to treat it. What is the standard of proof? What are you, the defense attorney, burdened with? Is it beyond a reasonable doubt? No, of course not. That's silly. That's for prosecutors. Is it anything on the famous defense staircase or any of those other lovely charts that you like to use in your closing arguments, or if it's a pyramid? I think Finnerty had someone in one of his trials try to use the pyramid. No, it's a new standard that you're not going to find on any of these charts. It is a standard that maybe secretly always existed, but we just didn't talk about, which is satisfaction of the court. You got to make the court happy. What does that mean? Well, there's not going to be any case law on it. You're not going to find anything that says, this is clearly meets the court satisfaction and this does not, because that's going to be up to every individual judge. And the kicker, even if you meet the satisfaction of the court in all 6 of those requirements, it's still a discretionary call. Mental health diversion is not an entitlement. It is a discretionary opportunity that the judge has the ability to grant or not grant. And so that means you may file a perfect brief in the sense that the judge is completely convinced to the judge's satisfaction that you've met all 6 criteria, that you have eligible charges, and your defendant is suitable as well. But the judge could still say, you know what, even though you meet all the requirements, I just don't think this case is appropriate, and so I'm not going to grant diversion. Haven't seen that happen too often, but it is, I think, worth noting that it's not simply checking the 6 boxes and then you automatically get diversion. It's still ultimately the judge's call. Now, does that lead to some disparate results? Sure, it can. Every judge is different. Every judge is going to have kind of a different standard in their head as far as what is going to satisfy them. But I think, at least in Orange County, and the way we have diversion set up, it's not necessarily a bad thing. And the reason is this. There is no such thing as Orange County's mental health diversion program or Orange County's mental health diversion court. I can't tell you how many times I've been asked, or I've heard a defense attorney say, oh, I'm going to sign my guy up for this mental health diversion program. Or can you send us, can we get referred to the diversion court? It's like, there is none. What happens is you file a motion, you get assigned to some random judge, and that judge becomes the person who decides all this. So the reason I don't have a problem with the judicial satisfaction standard is because ultimately, whatever judge you get sent to for the motion, if they grant diversion, it's going to be on them to shepherd that case through the diversion process. And that judge is going to be responsible for all the progress reviews and for kind of setting the terms of, hey, here's how often you're going to have to come back to court. Here's what I'm going to ask you to do between now and the next time, and kind of setting those standards. So you want, whatever the standard is, you want it to be something that that judge is comfortable with, because it's not as simple as they grant diversion and then pass it off to someone else who then takes it the rest of the way. It becomes their responsibility here in Orange County. So please keep that in mind when you say, my guy is eligible for diversion, that you're just talking about the requirements, but you're not talking about what's going to happen after diversion is granted. That's a whole separate conversation. All right, so going back to those 6 requirements. Number 1, the defendant has to have a qualifying disorder. Similar to qualifying charges, it's easier to just tell you what doesn't qualify and know that everything else, as long as it's recognized by the DSM, everything else does qualify. Antisocial personality disorder, borderline personality disorder, pedophilia, those are the 3 that do not. So your guy carrying around bombs, your murderer, and your pedophile, they're the ones out of luck. Pretty much everyone else, if you can get an expert opinion with some other disorder recognized by the DSM, it is eligible for mental health diversion. And under the law, you must have a recent diagnosis by a qualified mental health expert. which begs two questions, obviously. How recent is recent? And what does qualified mean? And then we get that standard again. That is going to be up to the satisfaction of the court. That may be frustrating because it doesn't give you any guidance as to who you should talk to. But I think the flip side of it is really when we dig into that, it ends up being an argument more over weight, not admissibility. It also frees you up. There's not a set list of people you have to choose from. It gives, I think, especially with private attorneys, kind of the flexibility if your client does have someone who they've been seeing, someone who has a mental health history and someone who knows that history well. Even if that person is, out of county, not certified with a court or whatever, there's no such thing in diversion. I had one where the expert who was giving the opinion was essentially a guidance counselor from out of state who had spent time talking with the defendant. Now, did I put a lot of stock into that opinion? No, I didn't. But the argument wasn't that the person didn't qualify as an expert. It was more, what weight are we going to give to this person's opinion versus someone else? But there's no requirement that your expert has the ability to prescribe medicine or anything else technical like that. It's again, and it doesn't matter what the DA think, because this is always going to be, it's your burden as a defense attorney, and you have to satisfy the judge, not me. So it's going to be judicial satisfaction. Number two, you need a nexus between the disorder and the crime. This is along with the unreasonable risk of danger. These are probably the two that get fought over the most. And I could probably do we could spend an hour giving examples and discussing what we think is a significant factor, what's a nexus, what's not. Not going to do that here. But I would just note that it's a nexus for everything that you're trying to get diversion for. So we have some people that, file a mental health diversion motion and their guy has 4 or 5 open cases, and so they just file it on all 4 or 5. Well, there may be a valid connection between their disorder and one charge or a couple charges or even an entire case. But if you find it in one case, that doesn't necessarily mean it's going to apply across the board. You need that nexus for each charge, each case that you're trying to get diversion for. Number 3, the symptoms of the disorder will respond to treatment. It's important to note that we're talking about treating the symptoms, not the disorder. If you have a guy who is, bipolar, schizophrenic, you don't have to prove that you're going to cure the schizophrenia. All right, that's not going to happen. But what you are going to need is an expert opinion that the symptoms of that schizophrenia, the way that it causes the defendant to behave, and of course what we're concerned with is the bad conduct, what causes him to lash out or do whatever he did, that those symptoms can be treated effectively. And I put what treatment on here because remember, we don't have a mental health diversion program. We don't have a mental health diversion court. So it's not the court that's going to come up with a treatment plan. It's not someone else. It's going to end up being you, the defense, through whatever help, experts, resources you come up with. It's not something where you just say, all right, well, this would respond to treatment, and now court, you figure out how to make that treatment happen. It's not what mental health diversion is about. Very different than our collaborative court system. Number 4, the defendant consents to diversion. There's a technical exception here, but generally speaking, you can't impose diversion on a defendant. They have to agree to it. I can't force it on someone. The court can't force someone to do diversion, and even the defense attorney can't make someone do it. They have to agree. And that consent includes waiving speedy trial rights. Consenting to treatment, same issue. What treatment are we talking about, right? It's easy to say kind of in a bubble, oh yeah, I consent to treatment, but what exactly does that mean? If your guy, and I've seen this happen, if your guy thinks he doesn't have a problem and says, I don't need to take meds, I'm okay, I know how to manage myself. Well, is he really consenting to treatment? We need to know what exactly we're talking about. Finally, the defendant's not an unreasonable risk. the language in the penal code reads as an unreasonable risk of danger to public safety if treated in the community, which as a prosecutor, you read that part, you can say, all right, no problem. I can make my pitch. I can argue why someone's a danger or not a danger. And then they hit you with, as defined in this particular penal code. And what that means is we are talking about super strikes, murder, your violent sex crimes. So really what the standard is you have, again, it's still the defense burden, but that burden is simply showing that the defendant is not an unreasonable risk to commit a super strike. He's not an unreasonable risk if treated in the community to commit a murder, to commit a violent sex crime, or a couple others that are specifically listed, which really limits and narrows some of the arguments that the prosecution often has. It's easy to argue why someone may be a danger, but when we're making our arguments, assuming this is one that we oppose, we can't just say, well, he's dangerous. We have to say he's dangerous to commit a certain type of crime. Now, obviously, in any analysis, the person's rap sheet's going to be important. The current charges they're faced with, they're going to be important. But that's not the only consideration. And I would just, suggest that the facts, regardless of what's actually charged, the facts may lend themselves to arguments that someone's still a danger to commit something that they're not even charged with. And I'll give you an example. We had one. I'll change the facts slightly because I don't like talking about specific cases or giving specific information, but there's one where, let's say, defendant clearly had a mental issue, liked to lash out at people on the street, and did so by repeatedly kind of pushing people from the sidewalk into the street. And in one particular case, he did so. Of course, a car is driving by, ends up running over the victim's hand. So we have, 245, we have GBI, all that sort of stuff. We don't necessarily have a super strike, but the argument, for at least the argument that makes sense to me as a prosecutor, is, well, if say he's not responding well to treatment, and or if there's a relapse and he goes back to doing the same behavior again, it's not just a 245 that we could potentially be looking at. Because all that has to happen is, next time the car doesn't run over the guy's hand, it runs over the guy's head. And now we do have a super strike. So I only bring that up as an example just to caution it's not as straightforward, I think, as simply saying, well, he's never killed anyone before. He's not charged with killing anyone now. So clearly he's not an unreasonable risk to kill someone in the future. You have to kind of look at the context of what happened in your particular case and what could have happened, what else was kind of reasonably foreseeable. But fortunately, maybe didn't happen in this particular situation.
Hey, Jess, if you don't mind,
Sure.
I just want to remind everybody, because I forgot to say this at the beginning, that if you would please, in the chat group box to everybody, or if you want to do it specifically to Kim Wah, give her your state bar name, not your nickname, but the name that's on the state bar website, your bar number, and your email. We'll make sure that you all get MCLE credit. Okay. Thanks, Jess.
Sure, no problem. Next, how to file in the time of COVID. This used to be real easy for me. It used to be all these cases got filed in C5, and I had a nice little system worked out where I would get a list from C5 through our research department of every diversion motion that was filed there. And so I'd have a nice, neat little list and be able to track all these motions. Now, and for good reason, the court has a different system. So here is what we are doing, and this is going to go by again kind of fast, but I know this is being recorded. You can always go back and look at this if you want the exact process. Plus, the courts have put out on occourts.org their current process for filing motions. It's the same process as filing any other motion, which means that for prelim felonies and for misdemeanors, each courthouse and each branch DA's office has a specific email set up for receiving these. Here at Central, it's cjc.motions@da.oc.gov, but every other court has kind of a different address. I'm not going to list them all here, but they are available on the court's website. Post-prelim, it's a lot easier. If you file a diversion motion post-prelim, or any motion post-prelim, You only have to send it 2 places. Send it to covidmotions@occourts.org. And to serve our office, you just CC appellate@da.ocgov.com. And then our appellate division does a good job of kind of funneling those to get them to the right unit or the right DA from there. Once that happens, here's kind of how our office is handling them and how we respond. Again, if it is pre-prelim, most of those felonies are going to be handled by my unit. That's what our mental health division is primarily tasked with. There may be a couple vertical cases in there that the vertical DA wants to keep and handle themselves. That's totally fine. Misdemeanors are going to be handled by misdemeanor DAs. On the post-prelim side, currently those are being handled by felony panel or by vertical DAs if it's a vertical motion. I would love to be able to change that in the future once we get to a non-COVID, non-hiring freeze type setup and we can add more bodies. I think Rue would love to take panels diversion motions from them. But if you're thinking, oh, maybe I can kind of game plan this and kind of pick who I want to handle my diversion motion, I'll just let you know that I'm here in Central, panels down the hall, and a lot of them end up coming down here to ask me questions about them anyway. So we want to have, I only say it because we want to have a consistent approach anyway. So it's whether you do it pre or post prelim, this is how it ends up getting handled by our office, but hopefully you're getting consistent responses. All right, part 2, how do hearings work? And here's where I get away from kind of the technical requirements and just kind of ramble and pontificate about things that I think are good to think about and questions you may want to ask, both on the defense and the prosecution side. There are no rigid guidelines as far as how the hearing is supposed to take place, which means you, the defense, you have the burden. Again, I don't have to do anything. So you're, unlike most other things where I'm calling in wits and figuring out how to, get the evidence I want in front of the judge, that's kind of on you. One of the biggest issues that comes up is, do you need a plan already in place when you're filing your motion and when you're going to the hearing? Technically, in the statute, you don't have to. You can get that finding, you can argue the criteria, the judge can grant diversion, and then you can go about figuring out, placing someone in the right place. However, some judges require, or at least what I don't know if you want to call it a strict requirement, but I've seen them tell defense attorneys that that you don't have a plan. I'm going to deny this without prejudice, but if you want to come back with a plan that I can sit there and evaluate. Even if a judge is not requiring it, should you do it anyway? Should you take the time to figure that out, find a treatment provider, do the work before you even know if the judge is going to grant the motion or not? That's obviously a call for the defense. Personally, I strongly feel that it's a good idea for both sides, and I'll give you a couple reasons why. Number one, you may just be delaying the inevitable, right? You may be doing all this work, writing your motion, getting the judge to agree with you that he's eligible and suitable. He grants diversion, or at least he's getting ready to grant diversion, but now there has to be a plan. There has to be somewhere to send the defendant, some program to give him. And if you haven't done that, all you're doing is just making us all come back, hopefully with good news for your client. But what if that doesn't happen? What if you can't find a place? What if there isn't someone that meets the needs of the defendant as well as what the court is kind of looking for? Then it's just kind of like we did all this work and we had this hearing for nothing. So from that perspective, I think it makes sense to come in with a plan up front. The other reason is, to me, it makes my arguments as a prosecutor a lot easier, I think, when there's no plan. Because I don't know, and I'm not a judge, and the standard's always going to be what the judge is satisfied with, but I don't know how a judge can be satisfied that a defendant will respond to treatment if we don't know what the treatment's going to be. And I don't know how a judge can find that a defendant is safe out in the community doing a program if we don't know what the program is. So yeah, I make those arguments, and then, ultimately, usually what we end up doing is continuing it out, letting the defense come back with a plan. To me, it usually, when there's not a plan, it seems to delay the inevitable. But ultimately, it's not my burden, it's the defense's. So just something to consider. Live hearing or paper hearing. Again, there's no requirement. It's up to the judge. Some judges tend to want live testimony. Some judges tend to not like that and just want to argue on the motions. You don't know where you're going to get sent until after you file your motion. So I think it's probably a good idea, once you get assigned somewhere, to check with that particular judge and see if they have a preference. A lot of judges are neutral, and they're kind of like, hey, it's not my motion, it's yours, defense. So you put on whatever evidence you want to put on, and I'll sit back and I'll make a ruling at the end. Even if a judge doesn't require it, what are the pros and cons to doing it each way? I feel like either way is a double-edged sword. If you call, an expert witness, inevitably there will be information that comes out during that testimony that's not in their report. It's just natural when you're asking questions and they're explaining how they form their opinion. That could be good for the defense. It could be good for the prosecution. We don't really know until it happens. The prosecutor obviously gets to cross your expert. That could go well for either side. If you do a paper hearing, you take away that kind of randomness factor. You're arguing based on the report. What I will note, though, is it lets the DA kind of pick away. We get to critique the report. And if we think it's lacking, if we think that it doesn't address important issues, we're going to point that out. And your expert's not there to respond to it. So again, do it how you want to do it. But those are just kind of the pros and cons of the different ways of putting on the hearing. It's ultimately, most of the time, going to be up to the defense. And finally, if you do a live hearing, what does that mean? Who's going to get called? Are you just calling the expert who gave your opinion? What about the treatment provider? If you are coming in with a plan, one thing that has seemed to be helpful to several judges is to hear not just from the expert who diagnosed the defendant, but also to hear some information about where the defendant is going to be doing treatment. If it's not a program the court's familiar with, it's maybe helpful to have people from that program come in and answer the judge's questions. Again, it's totally up to the judge how they want to do that. Do they just have them behind the bar and ask them a couple of questions? Do they put them under oath and take testimony? I've seen it go both ways. So you're not going to know until you talk to your judge. But these are all different considerations for doing the actual hearing. A couple other things. Marcy's Law. Marcy's Law isn't there. The way the penal code reads, it says the court is to consider the positions of the prosecutor and the defense and any other testimony, or excuse me, any other evidence. It doesn't specifically note victims, but obviously with Marcy's Law, the victims are going to have a constitutional right to be present at this court hearing and to give a statement if they choose to do so. So just be aware that even though it's not specifically written into diversion, that still is out there. And then, as I mentioned, the format of the hearing, it does specifically say that these can be informal hearings. You can make offers of proof. You can use reliable hearsay. We're not doing a trial here. You're arguing to a judge. All right. What if it's denied? This is where we get to my favorite section, and it's not because I want to sit and gloat over diversion motions being denied. It's really to give you kind of behind the scenes of what we're doing on our end and how we approach these motions. Because I think there have been, at least in the past, there have been a lot of misconceptions about how the DA's office views some of these issues. And at least what we're doing with Rue, I want to put it out there and make it clear how we go about analyzing whether we're going to object or not to a motion. If your motion is denied, presumably the people have objected to it. Often it's because of the dangerousness issue. Sometimes it's the nexus, sometimes there's other little technical things, but most often for us, it's going to come down to public safety. And as DA Spitzer was talking about, ultimately our job is to protect the community and to try to do the right thing. And what we see in Orange County is that mental health diversion is an option. It is not the only way to get someone treatment if they need treatment. The way we kind of look at it is, look, there are different options. Mental health diversion, as we talked about, is not structured. It's you gotta go out and into the world and find your own program and come back and tell the court you want to do it. Our collaborative court system is very different. I'll talk about some of the differences in just a second. A little more structured, a little more formal, a little more supervision. And then obviously in custody is a whole different world. I'm not going to talk in this presentation about different in custody services that the Sheriff's Department is providing. That's kind of their world. And at least currently, it's not something that, it's really more of an opportunity for a defendant if they want to avail themselves of certain services at this point, as opposed to a formal program that may be coming in the future. But the diagram is kind of a way of representing that. Ultimately, there may be cases where both sides agree that this person has a mental health issue. We absolutely agree. We absolutely agree that they would stand to benefit from some treatment. We just disagree and think that it's too much of a risk to have them out into the community getting that treatment. And because these other options are available, we're objecting, and we're in a different position than the defense. Our bottom line is always going to be public safety. We're trying to accomplish both. We're trying to accomplish public safety and getting a defendant the help that he needs. But the tiebreaker will always be for a prosecutor, public safety. And as long as we have this system, there will be cases that we disagree on, where the defense thinks that mental health diversion would be totally appropriate and he would totally not be a risk. And we're just going to agree to disagree. But I want to make it clear that if we're disagreeing, it's because of this issue most of the time. It's not simply, prosecutors don't like programs. They just want to lock everyone up and put them in jail. We are both trying to get the defendant from point A to point B to point B. We just disagree on the best vehicle to get them there. So ultimately, a lot of the times we oppose diversion, we are actually not opposed to collaborative courts in CCB1 and everything that Judge Krieber is doing with some of those mental health courts over there. Here are some of the differences and some of the reasons why we might be opposed to one but not the other. One of the big ones, obviously, for the defense is that in collaborative courts, you plead up front, and in mental health diversion, no plea is required. Proceedings are essentially put on hold while the diversion process is going on. And if it doesn't work out, you just go back to the same status that you were at before the diversion. So obviously, I understand that's a huge incentive and a huge advantage for the defense of preferring diversion. Here are some of the other things when we talk about, why would one be viewed as a better public safety option for a prosecutor? Well, collaborative courts, you're going to get a probation officer assigned to you. Diversion, obviously, you haven't pled guilty. You're not being placed on probation. That's not happening. You're not going to have the terms of probation. Collaborative courts, you have someone that can, knock on your door, search your stuff, look at your cell phone, make sure that you're doing what you're supposed to be doing, those sorts of things. In the collaborative courts, you're going to have a team assigned to you. There's a defense attorney, a DA, the judge, obviously, healthcare, probation officer, and depending on which court, usually a couple other people that get assigned to work on your case and to try to work collaboratively to come up with the best program for you. Mental health diversion, who knows? It depends on what you find out there. Some programs may offer things like that, some may not. It's completely up to what the defense is offering, and I've seen such a huge range of some programs that really were equal or maybe even more secure and supportive than the collaborative courts, and then others that were so bare bones. it really wasn't even a program. So the results vary wildly with diversion, whereas collaborative courts, you kind of know what you're signing up for. In diversion, though, obviously we talked about the proof of the nexus. In the collaborative courts, that may or may not have to be shown. It kind of depends on the situation in the court. So that may be an avenue for one where your guy clearly has a disorder, but the nexus issue is a little more of a gray area. Collaborative courts have clear, once they come up with a program and go through their process, they have clear phases and incentives and sanctions, and they everyone who's working that kind of knows what the program is going to be, how it's going to work. Diversion, again, who knows? It's judicial satisfaction, right? I don't know if a judge grants diversion. I don't know how long they're going to do it for. I don't know what the requirements are going to be. The defense can make a suggestion, offer a plan, but the judge certainly has the ability to change that up as they see fit. In both situations, collaborative courts or diversion, if you're successful, you're going to get your charges dismissed. So the same end result, but at least on the prosecutor side, in some instances, the collaborative courts are a safer recommendation for us. And so we've tried to do that. In several situations, we've started filing motions and we've made it explicit. We wanted to tell the court, look, we are opposed to mental health diversion, but we're not opposed to sending the defendant to CCB1 and getting them evaluated. Now, that doesn't mean, hey, the DA's approved, this person's automatically going to get a collaborative court program. That's going to be left up to Judge Krieber and the team, and they have their own criteria and requirements. But it does do a couple things. I think it gives our prosecutors credibility in saying, hey, we recognize this person needs some help. We just disagree that diversion is the best way to do it. And also from the defense side, it sends you into CCB1 with a piece of paper saying, hey, the DA wanted me to come here and talk to you guys. And one of the great things about RU is that having both the collaborative courts and mental health diversion under the same roof is there's no cross lines. We're not trying to bounce one person off another. Our diversion DAs talk with our collaborative court DAs. And so it's not something where the diversion DA say, no, go to CCB1, and then CCB1 tells you, oh no, go file a diversion motion. It's all under the same roof. And if we're doing our job in communicating, it's really just about finding the best location that will help the defendant out while also protecting the community. And it's just, more stuff that we put in the briefs, and we'll say explicitly in there, we agree that the defendant needs mental health treatment. However, this particular plan is insufficient to protect the public. So we're opposing diversion, but and it probably shouldn't say request, because really the DAs can't put someone in a collaborative court program. It's more like we would not oppose having the defendant sent to CCB1 for evaluation in one of those collaborative courts. So we've started keeping some data, and this is kind of what gave me the first sign that it's actually working, this new process and what we're trying to do in RU. I went back and looked at all of the diversion motions that were either denied or withdrawn, because I wanted to see what was happening to these defendants. Obviously, the defense felt they had some mental condition worthy of filing a motion. What ended up happening after their motion got denied or after they withdrew it? Did they plead guilty? Did they go to trial? Did they end up getting a sentence that gave them some sort of treatment, or did they just go off to jail? And without RU, only about a quarter of the cases that got denied or were withdrawn from mental health diversion ended up making their way to the collaborative courts. So basically, for 75% of diversion motions, if diversion got denied, then that was it. You were done. Back to the old way of doing business. On RU motions, it's, as you can see, drastically different. 60% of the ones that are denied or withdrawn still make their way over to the collaborative courts, in part because of those non-oppositions that I was just showing you, and then also because having them under one roof, both diversion and collaborative courts, means that sometimes if a charge doesn't qualify for the collaborative courts, we'll give waivers and we'll let someone in because we think this particular case is not good for diversion, but is good for collaborative courts. And so really, it's something where the more we can talk with the defense ahead of the motion, sometimes we can, save a lot of time, preempt something, and work out a solution. But this is really what we're trying to do with RU. It's not about, it's not about labels or anything like that. Calling yourself a recidivism reduction unit. It's not about being able to say, oh, I'm tough on crime, or I'm a progressive prosecutor, or any other label you want to give. It's really just making sure that we are doing our job, doing the right thing, and also protecting the public. And if we can do all that, then that's a success.
Another pillow over there?
All right. So what if your motion is actually granted? What does that mean? Does that mean you shake hands, say congrats to your client, and then walk away and check back with them in a couple years? No, not at all. That is really just the beginning. After diversion is granted, there will be a series of progress reviews. How many progress reviews? I have no idea. What are the requirements going to be? How far apart are they going to be? I have no idea. This is all going to be judicial satisfaction. The one thing that is required, though, is that the treatment provider, and who's that treatment provider? I don't know. That's whatever you come up with and the court agrees to. But whoever that is, they must provide regular reports to the court, the defense, and the prosecution. What does regular mean? I don't know. That's up to the court. What about restitution? Ultimately, these cases will be dismissed if the defense is successful. How does restitution factor in? The court shall hold a restitution hearing upon request, which I assume will usually be upon request of the prosecutor. And if any restitution is owed, the court can order payment during the diversion period. However, inability to pay cannot be the reason to deny someone diversion or find them out of compliance with the program. So how does it all come to an end? When does it end? I don't know. There's no set time for diversion. Well, there's no set minimum. There is a 2-year maximum. So if your guy's kind of having some struggles and it's taking longer than everyone thought it would, the longest they can be in is 2 years, and then it's kind of fish or cut bait time. Someone's going to have to make a call, and really that means the court, as to what we're doing with the case. Does that mean, you get the case dismissed after 90 days? I hope not, but technically that's possible.
Not very many people.
All right. So what happens if the defendant performs satisfactorily? Charges are dismissed. End of the case. The arrest is deemed never to have occurred. The client can legitimately say he was never arrested for that offense per the penal code. So that's obviously a big benefit. What does it mean to perform satisfactorily? According to the law, that means substantial compliance. What is substantial? I don't know. It's up to the judge. No significant new law violations. What are significant? I don't know. And the defendant needs a long-term mental health care plan. Of course, the other way that diversion could come to an end if the defendant does not perform satisfactorily is because it's terminated. And it could be terminated for a few different reasons. The defendant could always choose to withdraw and say, you know what, this isn't working for me. I want to go back to the regular criminal justice system. Let's end these proceedings. Fine. Non-compliance with the program as deemed and decided by the court. I suppose that would also include the case could go into warrant status, failure to appear. After a period of time, the judge could choose to terminate the diversion. Or, of course, if the defendant commits a new crime while in diversion. However, committing a new crime while in diversion is not automatic termination. What it means is that the court will hold a hearing. The penal code says the court shall hold a hearing if someone's in diversion and they commit either a new felony, a new misdemeanor that reflects propensity for violence, or they are, quote, engaged in criminal conduct rendering the defendant unsuitable. What does that mean? I do not know. But that is the very official, very important legal standard. Basically, you're going to have a hearing and argue it out. So, a few questions to ask, and as I kind of wrap up here. I think these are things to think about up front. What level of supervision will give my client the best chance to succeed? I know diversion has that big shiny carrot of not pleading guilty, but that doesn't necessarily mean it's putting them in the best position to succeed. Do I have a program in mind already? Do I need to have one in mind already? Or who do I need to talk to get some ideas about possible programs? And then who should I reach out to? Is this something where, you know, I want to pick the brain of the RU DA who gets assigned this and see what their thoughts are before we even get to the hearing, and see if maybe there's something that we can work out or not. All right, so that's about it for me. And obviously I am here for questions, comments, thoughts, insults, anything else. Thank you.
Insults even, Jess.
Yeah,
Insults even.
I'll
No,
take
that,
them all.
hey,
I'll just mute it if it gets better.
I'm going to start off by saying that was an excellent presentation, Jess. Thank you so much. I've been doing a couple mental health diversion motions, and I thought I knew a little bit about it. I know 10 times more than I thought I did, just having listened to this for the last 50 minutes or so. So thank you very much. I mean, really, you covered everything very logically, very systematically, and I don't think you left anything out. I think it's great. Do you mind sharing the PowerPoint with us, Jess, so that we could post that on the NOCBA website?
Of course, yeah, not a problem.
Awesome. Then because there's been some questions to that. So we will definitely make arrangements for that. Does anybody have any questions of Jess?
I do.
Go ahead, Ray.
And I dress just like you so that I will not be
I appreciate you following up with
everybody.
the new Ray dress code. Thank you.
First of all, thank you, Jess, for a magnificent presentation. I have a case which I honestly think does qualify in Harbor Court, something like an assault with a car, assault with deadly weapon by this crazy client against her boyfriend. So my question for you is, so there's no assigned judge to file this motion with it. I have to file it at the arraignment, pretrial. Which stage do I file this motion?
Well, if you are filing it pre-prelim, you're going to file it with the Harbor Court email address, which I don't have on the PowerPoint, but you can get off the court's website and CC the Harbor Court DA's email. They will route that to me. I will assign it out from there, and someone will be in contact with you.
Okay.
Hey,
so
Jess, if I could ask you to take off the share screen, then maybe we'd be able to see everybody too.
Oh, sure.
So the follow-up question to this, let's say by some miracle, I'm successful in my motion and my client gets into the program. You said a lot of I don't knows and I don't knows because this is a very uncharted area, and I appreciate that. But, you know, in a typical diversion, you'd be looking at 6 months to a year or a maximum of 16 months. You said there's a maximum of 2 years, but there is no minimum?
That's correct. So it's, you know, it kind of surprised me because, you know, our code, it's TCB1, they're typically about 18 months.
Right.
You know, sometimes for misdemeanors, you'll have a shorter program, but there's no minimum. But again, you're going to have to satisfy the court. I would probably be jumping up and down if someone came in and said, yeah, it's a 30-day program and everything will be all good and we'll get the case dismissed. You know, I look at it as if it's a significant enough issue that you're arguing it caused them to engage in some violent conduct, it's probably going to need a little bit of time to work itself out and have time to go through the process of recovery and maybe relapse and everything else that comes along with that.
Hey, Jess, I have a question if I can throw it out there.
Sure.
Please, Rudy.
Okay. So I have a guy who was granted mental health diversion. Unfortunately, his mental illness got worse. He's had a conservatorship imposed on him. He's been found to be gravely disabled. He has now a conservator. Does your office, I mean, it's a public guardian, the county council came in and established a conservatorship over him. Is there any policy on what happens now with the mental health diversion that he was in?
There, I don't want to misspeak. I will say there are a couple sections in 1001.36 that talk about when someone is gravely disabled and has diversion terminated, that they go to, they basically can be placed in a conservatorship. As far as our office, we do, one of the things we do in the mental health division is we have a DA who kind of specializes in those issues. And I'm, I'd be happy to, if you have questions about kind of what the next step is, I'd be happy to connect you with her and
That'd be
figure
great.
out what's going on in this particular case. Yeah.
Can you send me that, or?
Yeah, I'll shoot you an email.
Yeah, you know that email address at the end of the presentation, Rudy? You wrote that down, right?
He has my email address because I've asked him stuff before. So sorry, Jess, I keep peppering you with email.
Jess, this is Kate Corrigan. Can I ask a quick question? So, I bug you daily pretty much with private bar questions. Would you be okay with me forwarding your PowerPoint to the private bar, to my distribution list?
Yeah, I mean, I didn't put anything in the PowerPoint that, I think is, obviously I knew who I'm talking to. So no, I don't have any issue with it. There's nothing secret in there. A lot of it's,
okay,
right out of the code and kind of summarizing and just throwing some issues out there. So
yeah, I just think this is super helpful. You've been super clear, and I think you've taken some of the, the big question marks out of this whole process. So thank you very much for doing this.
Sure.
Yeah, and I agree with Kate. I think that you're going to get better motions that will be, hopefully, will address those issues in a better way rather than, I imagine you get a lot of these that get sent back just to fix, numbers 2 and number 4, and then come back and get filed again. And hopefully we can streamline it and people know what they need to do. And it certainly seems to me, and in the couple I've done that, not in Orange County yet, but that I've done, I think including the treatment program is paramount. I mean, I think without that, it's very difficult. I know the code doesn't require it, but I certainly encourage everybody to do that. Any other questions? I know that there's lots of questions.
Jeff, can I ask a question?
Absolutely. Who's this?
This is Maltese, Jeff. Hi, good evening.
Maltese, it just says iPad. Maltese, how are you?
I'm good, thank you. Jess, if a client has been diagnosed with antisocial personality disorder, and then they have another disorder that is qualifying under the DSM-5, is that an automatic disqualification because of the antisocial personality disorder?
You're saying if they have one that qualifies and one that does not?
Correct.
I think, God, again, I don't want to misspeak, but I think that, yeah, I don't want to misspeak. We're being recorded. I'm not going to put it out there. I will look into that. I think I know the answer, but I'm not going to put it out there.
All right, and thanks for the presentation. I thought it was really good and helpful.
Thank you.
You're welcome.
Yes, and just as a caveat, everybody knows Jess is doing the best he can to answer questions. We're not holding him to anything he says here. It may or may not conflict with the code. If he's answering your questions, he's doing it off the cuff to the best of his ability. And before I go to the next question, I just wanted to add, I mean, I'm just so impressed with your presentation. I also wanted to add how impressed I am with Todd, our DA, for creating RU, and how the extraordinary changes we've been having in this short period of time with Todd as our DA, and really being open to, now don't get me wrong, doesn't mean that they roll over. It doesn't mean that every one of your petitions is going to be granted.
Don't say that.
Jess already pointed that out. But as you can tell from the presentation, they're very open to these things. They're inviting you to file the motions. It doesn't mean that they're going to roll over on them, but it doesn't mean that they won't submit. I have heard times when they've submitted on the motions, or as Jess has pointed out, where they may think that yes, they agree that there's issues, but there's better ways for it to be handled, like collaborative courts. Who's got our next question?
Jeff, I just want to make a quick comment. Kate, if you want additional presentations, I'm worried the PowerPoint, it doesn't speak for itself. We're happy to make the presentation. But I think what's so important is the message and the messenger. So I would just, I don't mind it out there. I just would like the opportunity to present it live to other audiences.
Oh, yeah, no, that would certainly be the pitch on it, because there are a lot of questions out there about this. And I think this is one of the only meaningful programs that I've seen out there. And so, no, I totally commend the North Bar getting this together, and then for Jess volunteering to put on such a substantial program. So maybe what I can do is, maybe why don't I connect with Jess, and I'll hold off on doing anything with the PowerPoint, but yeah, absolutely. I think this is a topic that is, you know, it's something that we should all be well versed on as on the defense bar side.
Yeah, absolutely. I agree. And I don't mean to put you on the spot with the PowerPoint. We'll talk with you, Jess, and with Todd. And if that's something we could do, great. If we can't, no worries. Next question.
I have a question.
Yes, go, Jackie.
Thank you. And you might be getting tired of hearing it, but I'm so grateful for you giving such a substantive, I mean, it was like the best hour I've spent in a really long time, and I'm a better lawyer for it. So I have a lot of good things to say about this, and I'm really grateful to all of you.
No, I won't get tired of hearing that.
Yeah. Thank you. So, and you know, on behalf of all of our clients, I thank you. But I guess, I don't know if it's for Jeff or for Todd, but my question is, without getting into like specifics of any particular case, like when you were talking about this program, and as you talk about it, it's a very, you know, we could sort of all agree on these things. It's really hard to disagree with anything you're talking about, and it's very progressive. But I'm wondering how much, like, is this something that is discussed with all of the line deputies? Because I know that, and all of the, you know, the vertical deputies, because the very moving discussion that Todd gave as to sort of his point of view, many of us, if not all of us, share a story like that. It's very compelling, but I don't know that, I'm curious about whether all of the office is aware of the sentiment of that leadership. And because when you have a felony case and you're there with your vertical deputy, that person may or may not find any value in either collaborative courts or mental health diversion under any circumstances. So that's my question, is sort of how much is there going around in the office about that sentiment, or is it really up to the deputy that you get?
Well, I can speak as to what we're trying to do with RU, which is, you know, we probably will never have so many deputies that we can just put people, you know, throughout all units of the office. But what we can do is train. And the vertical units are always going to be a little different. You know, if I was in sexual assault still, I wouldn't want to hear much about this mental health diversion thing. And I don't personally, I still wouldn't think that that's appropriate in most cases. But there's, I think, a sweet spot, it kind of in the middle of the criminal justice system of kind of general felonies, cases that get assigned out to the branch courts. You know, that's the bulk, the major volume of what we do as an office, even though, you know, some of the high profile stuff will get more attention. If you're talking about quantity, most of the cases are what's out at North and West and Harbor and Central. And so what we do in RU is try to go around and train the branch court DAs on some of the stuff that we're working on. And it's a thing in progress. I mean, we've been together, we've had RU, it's only existed for a year and a half, and 6 months of that's been COVID, where everything's been kind of put on hold. So it's still growing. Obviously, you know, more people, we can do more, but definitely there's a training component that we're getting out. And for general felonies, you know, if we're not talking about homicides and sex cases and gang cases.
In particular, I would just say, like, in particular, I'm thinking about like the domestic violence vertical unit, for example. I'm sure that these kinds of cases arise in greater numbers, for example, in maybe that kind of a unit. I'm just wondering if everyone in the office is sort of trained in the same sentiment.
It's, you know, it's something we absolutely talk about. Ultimately, you know, if it's a vertical family protection case, those DAs who are assigned to it, it's their case. And I'm happy to give my thoughts. I'm happy to talk to them and explain, you know, kind of how diversion works and collaborative courts or whatever. But ultimately, they have to be trusted to make their own call, I think.
Yeah, I should probably weigh in on that. Look, Jacqueline, I try to impart this sentiment throughout the office, but look, I'm the elected DA, but my phone works too. So there are attorneys who call me directly, and I do like the chain of command, right? Because you got to follow some protocol. But if you don't feel that your case is being addressed properly, then you simply need to call me or email me. I mean, I have gone with some people who are on this call to jail with them to meet their client, okay? So, I mean, I just feel so strongly that I'm available, and I don't want you to use the opportunity to call me, you know, every day, but you certainly need to talk to the assistant or to me if you feel that you have the right case that needs to be addressed in a certain way. So it's going to take some time to train all the prosecutors in the office, but I'm always available, okay?
Yeah, so we've
Thank
never
you.
had that
That's
from a
good to
DA
know.
before. Thanks, Todd. He's obviously been very responsive to emails and also people calling him. I know that from several attorneys, and I think a few of them that are besides me that are here on this list. Before I go to our next question, if you haven't already, make sure that you've sent in the chat your full name, your bar number, and email so that Kim can make sure you get your MCLE. Who's got our next question? We're out of questions.
I don't have a question, Jeff.
Dr. Herring.
Hi, guys.
And Dr. Herring's from Insight, as we talked about from before. We thank her very much for sponsoring, and one of our providers and sponsors that could probably very well assist in this. Dr. Herring, go ahead.
Right. So thank you. Great presentation, Jess. And it's just lovely. And I've had the privilege to work with some of the best criminal defense attorneys, and a lot of you are on this Zoom meeting right now. And Insight actually has 10 clients that are involved in the mental health diversion or have been granted or approved for the motion to do that, and actually went to Long Beach Court today. And the judge in Department 12 granted the attorney's motion, and this gentleman will start. And one of the things that I've found helpful from the treatment standpoint is to go in with the evaluation from the qualified mental health provider. But then what I also do is I write out a 2-year treatment plan, which consists of, residential, intensive outpatient, outpatient. So it's a breakdown of specifically what the defendant or your client would be doing. So the judge isn't sitting up there going, well, what is this program? What will they be doing? And it just kind of takes the pressure off. I know the attorney was very pleased with that today. And I think it was the second time that we appeared in front of that judge, and she granted the motion. So it's been really successful to kind of have your ammunition, like Jess was saying. So if you want any information from the treatment standpoint, even if it's a different treatment provider, I'm always available because sometimes we're not a good fit for everybody. So it's just, again, want to say thank you for the great presentation, and it's good to see a lot of you.
Yes, we've got great resources here. Dr. Herring is obviously one of those to be very helpful. I know Winter McDaniel can help out with some of the things through Nancy Clark and Associates. We've got some great resources. Do I have any other questions before we call it a night?
Yes, this is Winter.
Winter, yes.
Since
Please,
you mentioned my name,
please.
I wanted to kind of, speak to the fact that, again, the presentation was amazing. It was very helpful to me as I just recently sat in on my first mental health diversion case, and it was granted. And so we are a resource for that particular client. And so if any of you guys need treatment providers or resources, we are definitely able to assist you in that matter. And I want to thank Jess and Mr. Spitzer for the lovely presentation. Thank you.
Thank you, Winter. And most all of you are familiar with Nancy Clark and Associates, and Winter is a representative for them and another great resource for you. I'm going to give it as one last question. No? Well, with that, I wanted to make a comment about Peter Finnerty. Thank you for joining us. And, when you had your daughter on your lap, you got that big ogre, thing I think about you whenever I see you. And now I look at you as a nice, compassionate person, so I think you ruined my whole perception of you, Peter. But, it was worth it. Anyways, thank everybody very much for joining us tonight. If for some reason you didn't get out your information for MCLE, feel free to email me or Kim or anybody on the board, and we'll make sure that you get your MCLE credits. Again, I wanted to thank Todd for joining us tonight, and Jess. I know it ran a little bit longer than we thought it was going to. Thank you so much for your patience. And really, I always say that we have great presentations because we generally do. This was just so well organized. Thank you very much.
Thank you all for having me.
Okay.
Thank you very much.
Thanks,
Thank
everybody.
you to you. Thank you to you too, Jeff. Thank you.
Thank you.
Thank you.
Yeah.
Good night, everybody.
Thanks, Jess.
Bye.
Todd,
Good night,
Jeff.
everyone.
Hey, Bye, Paul, Jeff. you're a Thanks. little late to the party.
Thanks, Jeff.
Good night, Your Honor. Paul
Good night,
Christopoulos just joined
everyone.
us. Better late than never.
That's me, the feed.
Hey, Paul, better late than never. You're here, but we're just finished up.
Oh, wow. Did Paul just log in?
Yes. He's trying to sneak in for those MCLE credits.